All owner-architect agreements are personal service agreements between two parties. The parties can be two individuals, or they can be between a business entity and an individual, or they can be between two business entities, but nonetheless they're all personal service agreements. Each party is expecting to deal with the other party throughout the entire course of the project. They don't want to be surprised and have their agreement assigned to yet a third unknown party and then have to deal with some party you never planned to deal with in the first place, or maybe you don't want to deal with in the first place. So therefore, most agreements, owner-architect agreements, contain a non-assignment provision. That provision binds the owner and the architect and all of their agents, successors, assigns, legal representatives, and so forth to the terms of this agreement. The owner says to the architect, well, no, wait a second. I'm bound under my agreement with the lender, my lender, to assign the documents to them should I default. So I can't really sign this non-assignment provision, and I need an exception so that if I default, the lender can take over the assignment of our agreement and complete the project. And you can imagine most lenders want to have the ability to receive the assignment of this agreement so that they can, in fact, complete the project, not because they want to complete the project on behalf of the owner, but because they want to protect their interest in the project from the money perspective, from all of the funds that they've provided to build the project. So it's not unreasonable for a lender to ask for an assignment provision. The tricky part comes in wherein it's the borrower, your client, the architect's client, who's defaulting. And I can only assume that if the borrower is defaulting, he's most likely not paid you, the architect, for the services you've performed up to the point of his default. And suddenly, the contract is now going to be assumed by the lender under this assignment provision, and the lender is agreeing that he'll pay you from this point forward. But he's not agreeing that he'll pay you for the past services you've performed that the borrower refused, your client refused to pay you for, or was unable to pay you for. If you'll look closely at the language of section 10.3 of the AIA B101 2007 version of the owner-architect agreement, you'll find that it discusses this assignment in terms that we've just discussed. And there's nothing in there that protects you, the architect, against the borrower's default and that unpaid portion of work that you've performed. So I would take that paragraph, 10.3, and say that the owner may assign this agreement to a lender. This is exact wording of the AIA provision. The owner may assign the agreement to a lender providing financing for the project if the lender agrees to assume the owner's rights and obligations under this agreement. I would add in, including the obligation to pay for all unpaid work performed for the project for the client. That way, the bank will not be able to accept the assignment without paying you for the work that you've already performed. And don't you think that's a fair provision from the perspective of the architect? You've performed the work properly. You had nothing to do with the borrower's failure, your client's failure to perform, meaning to pay you. And he's defaulted in his loan agreement with the bank. It's not your fault. You should be paid for those services. And the bank shouldn't get those services for free just to protect its money. So I would add that in 100% of the time.